Good evening, welcome to my YouTube channel. My name is David Okun. I'm talking about work in the United Kingdom. If you have watched this video, watch this video and the rest of the videos on the topic. It is a continuity of discussion. And when we talk about a work situation in the United Kingdom, we are considering factors including globalization and the similar political and economic infrastructure across the globe, where what happened in the United Kingdom also happened abroad, including in Africa and the rest of the continent of the world. So whatever situation is available in the UK, pay attention. If you are not in the UK, if you're in the UK in particular, it's best to try to understand these factors. I've been talking about work. Work is a private, it's a public factors of the economy. It is to be found within businesses, as in private and public sector. I've discussed the economic system and the market economy, where there is shifting, moving away from the public to the private. We have had capitalism from the beginning, but in the course of history, we have looked at capitalism being moderated by the public sector. Now the tide is changing increasingly politically in terms of economic, in terms of market, in terms of businesses, where societies are drifting away from the public to the private sector. So when we look at employment, we consider work as a source of a primary source of income in the United Kingdom, and also we have in the United Kingdom an equivalence of money given as in form of financing given to British people in terms of managing or moderating income for the people of Britain. I'm so grateful that you came, and if you haven't subscribed to this channel, subscribe to the channel. If you have already subscribed, thank you so much. Click notification bell and also click like. When you are watching the video, you can share with family and friends in order to support this process if you value it in some way, if you don't value it some way. Because to succeed as a society, we have to do some work. And that's why I'm talking about work, especially in light of the rapid changes within technology, engineering, as I have mentioned in the other videos, because work is now being taken away by the machine. It's about time now to understand in fair detail the situation in the environment. We are looking at the law governing work, in particular employment. Today we will be looking at claiming breach of contract at an employment tribunal. There is employment tribunal is a legal entity designed to arbitrate between employer and employee in dispute, and when there is a breach of contract, such as happen often. Leave a comment below if you have experienced breaches of contract. If you understand contract, if you don't, you maybe watch the rest of the video and leave a comment below. Let me know if there is a need to learn more about contract. Contract is way of life, is law. It governs life at every segment. This is an opportunity to learn through employment contract, the essence of contract, the dynamism. Is fairly complex, but it is something we pay attention to, which we need to do. And we're looking at employment tribunal. If you are an employee, you come into a relationship, a legal relationship, a contractual, and when you are in a contract, the understanding is to keep a contract, to maintain a smooth running relationship. However, in lives, often a lot of things happen where the situation arises where employer or employee disagree about contract credentials, and also its compliance and its applicability. and its performance, where there is a breach of such a contract, and there is a claim for remedy, and that is what I'm trying to talk about in as normal a language as I can. Thank you so much for being part of this economy, this platform, YouTubing. So grateful. So let us look at someone in a situation of having to claim in relation to a breach of a contract of employment. Somebody who has left a job can also can normally make a claim to an employment tribunal for breach of contract, for unpaid wages. Wages is what you get when you do work, is money normally, or it can be paid in kind depending on the agreement between an employee and an employer. So we are discussing this as a body of knowledge which I believe is of value, like I have done. And if you need to know one or two things about employment or something else, it is now the time, because we live in an age of knowledge. And also as in terms of society, we are expected to take responsibility for your life. In the past, we used to depend on the state. Now, in terms of law and access to justice, there is a problem where there is limited resources coming from the government, as it has dwindled or stopped altogether in trying to finance the public sector, including access to justice, where legal aid is intended to support claimants who may not be rich, may be an ordinary person like a man and woman on the street. This funding is drying up. We have talked about the cuts in public funding, and it applies also to access to justice. Such as we are trying to discuss. There is a need, therefore, if you are an ordinary citizen of the world, which you are not a multimillionaire, it is a need for empowerment. You need to empower yourself, because if you don't have money, you can represent yourself in court. So that's the basis of learning, and this material is part of learning process. Leave a comment below if you're learning anything at all from this material. Leave a comment below if you're not learning anything at all. We are here to talk, and thank you so much. So this is a different provision from that, allowing someone in such a situation, an employee, to claim for an unauthorized deduction from wages. There are different claims, there are different types of claim. This is distinguishable from the other type of unauthorized deduction. For example, when there is a breach, so somebody who is in such a situation as an employee who is still employed cannot take this action against their employer. Leave a comment below. Let me know what you think about this process and this body of knowledge. So the maximum amount that may be claimed is to 25,000, and the time limit is 3 months from the date the client finished work. The client being someone like you and I, an employee who is in a situation trying to make a claim when there is a breach or that kind of injustice. So if somebody in your situation wants to claim only unpaid wages, it will always be available to claim under the unauthorized deduction procedure. Watching this video, watch it with the rest of the video for it to make some sense or some modicum of intelligibility as such. Thank you so much. So this is because under the procedure, the employer is not allowed to make a counter claim. So a counter claim is if someone, an employee, make a claim under other circumstances, the employer can also make a counter claim, and under this condition, the disallowing of counter claiming. Under the breach of contract procedure, the employer may counter claim for any money that they believe they owed. So we are making distinctions between normal contractual or relationship and obligations. Stay tuned. Continue watching. Thank you so much. So stay tuned, continue watching. Let us continue looking at claiming discrimination and the condition of employment in the United Kingdom. So if you are in a situation where you might be able to claim direct discrimination, if your employer has changed the term in your contract relating to pay on the ground of their age, disability, gender, reassignment, marriage and civil partnership, pregnancy and maternity, race, religion, and belief, sex and sexual orientation. These are the elements to be considered. So in such a situation, they might also be able to make a claim for equal pay if the change is made on the ground of sex. Where a change in a contract has had a disproportionate impact on a particular group, it may be possible for somebody from that group to claim indirect discrimination. For example, if they are the lowest grade in a workplace has had a pay cut and the majority in that grade are black, it might be possible to argue that this constitutes indirect race discrimination. An advantage of making a discrimination claim is that there is no upper limit to the amount of compensation that may be awarded. A tribunal might also award compensation for injury to feelings. The person suffering that consequences can also make a claim without having to leave their job, and can claim at the same time as taking any other action. If you're interested in this topic, you can do a further study about claiming discrimination. Let us look at changes in hours. An employer may want to change the employee's hours of work in one of a number of ways, such as in the following, such as follows below. Reduce the number of hours worked so that the employee earns less, or increase the number of hours worked, and or change the hours without changing the total number of hours worked. For example, moving the employee from a night shift to day shift. And these are scenarios where an employer may want to reduce the number of work so as to reduce the cost of employment, the level of pay to the employee. If the employer wants to reduce the employee's hours of work so that they earn less, this is actually a pay cut. Unless the contract contains a variation term allowing the hours to be changed, this will be a breach of contract and possibly an unauthorized deduction from wages. So someone in this situation, therefore, has the same options as those described for the cuts in pay. So someone in this situation would have to show that they are able and willing to work the original hours. So if an employer wishes to increase a client's hours or change them without altering the total hours to be worked, this will be a breach of contract, and someone in this situation may refuse to work the additional or alternative time if the contract does not include a variation term. So if you are in this situation and you refuse to work the new hours, you may be dismissed. If you are in a situation and you are someone who is in a situation refusing to work, someone in this situation who refuses to work the new hours may be dismissed. and they will only be able to make a claim for unfair dismissal if they have worked for the employer for the qualifying period, and they can show that the employer acted unreasonably in dismissing them. So if someone doesn't object to the change in hours within a reasonable time, they will be deemed to have accepted it, and the contract of employment will have changed accordingly. An appeal tribunal has said that if the variation refers to a matter which has immediate practical application and the employee continues to work without objection after effect has been given to the variation, then obviously he may well be taken to have impliedly agreed. A reasonable time, therefore, really means as soon as possible after the change has been imposed. Stay tuned, continue watching. Someone can negotiate on hours of work as between employer and employee. So someone wishing to object to a change in hours should try to negotiate with the employer. This is the guidance. We are also looking at legal remedies and hours. So it will usually be in the best interest of someone in such a situation to negotiate first before starting legal proceedings. It is always important to act reasonably, and particularly if it is later necessary to bring a claim for unfair dismissal. So someone with such a legal remedy, if you are in a situation where you have a limited legal remedy because a change in the hours doesn't necessarily result in a loss, and so there can be no claim for changes. The possible legal remedies are: you can leave the job and claim constructive unfair dismissal at an employment tribunal, or you can claim discrimination or redundancy. Looking at redundancy, if you are a reduction in work hours can create a redundancy situation. If the employer's need for work of a particular kind has diminished, the employer might then be entitled to redundancy payment if they have worked for 2 years or more. However, in order to claim a redundancy payment, the employment must have terminated. This could be either the employer dismisses the employee for refusing to accept the reduced hours, the employee resigns in response and claims constructive dismissal. There are also situations where the employee can claim unfair constructive dismissal, or in the alternative, fair constructive dismissal by reason of redundancy. Stay tuned, continue watching. You might be in a situation to claim constructive unfair dismissal. So to make a claim of constructive unfair dismissal, you must give up your job. This should therefore only be considered as a last resort. So to be eligible to claim constructive unfair dismissal at an employment tribunal, an employee must have worked for the employer for the qualifying period. So if you're in a situation and a person who wishes to claim constructive dismissal, they have to show that the employer has breached such a fundamental term of the contract of employment that they're entitled to regard the contract as being at an end. Usually, a change in the hours is regarded as such a fundamental term, provided that there isn't a variation term in the contract allowing such a variation, such a change. For example, in one case, an employer was found to be in breach of contract when they moved 4 employees, each working 25 hours over a weekend, onto various weekday shifts and increased their weekly hours to 42 hours. Stay tuned, continue watching. Thank you so much. So, to make a successful claim of constructive dismissal, somebody in such a situation also has to show they didn't accept the breach of contract. The easiest way of demonstrating this is this is for your this is for you to leave the job and to put in writing to the employer the reason they are leaving. So it is possible to stay working in the job under protest. So you can remain working under protest and also later resign. You can resign later. It is possible to stay working in the job under a protest and to later resign and claim constructive dismissal. But the longer you stay and waiting before you resign, the greater the risk you will be running a tribunal deciding that you had accepted the change. So the constructive dismissal is not automatically an unfair dismissal. The dismissal would have to be shown to be unfair under the rules of unfair dismissal. If you are interested to learn more about this situation, about claiming constructive dismissal, you can actually access the website. Like I've said previously, and it's important to visit the government website and also follow the procedure there. And also let us continue looking at how to claim for discrimination. So if you are in a situation where you might be able to claim direct discrimination, if your employer has changed the term in your contract relating to hours of work on the grounds of your age, on the ground of your disability, gender reassignment, marriage and civil partnership, pregnancy or maternity, race, religion or belief, sex, sexual orientation. These are the elements or the ground can be used, the ground capable of being used by the employer to apply discrimination. So where a change in the contract has had a disproportionate impact on a particular group, it might be possible for you from that group to claim indirect discrimination. For example, if the lowest grade in a workplace has a change of hours and the majority in that grade are women, it can be argued that this constitutes indirect sex discrimination. An advantage of making a discrimination claim is that there is no upper limit as to the amount of compensation that might be awarded. Also, a tribunal may award compensation for injury to feelings. The person suffering the consequences of discrimination can also make a claim without having to leave their job and can claim at the same time as taking any other action. Stay tuned, continue watching. You can learn more about claiming discrimination. So it is also unlawful for an employer to treat part-time workers less favorably than full-time workers, and unlawful for an employer to treat employees on a fixed-term contract less favorably than the employees on the permanent contracts. You can make a choice if you need to learn more about a part-time worker and their situations in relation to rights, also the right of fixed-term employees. So you look at cuts in fringe benefits or perks. Under these circumstances, if an employer wants to remove somebody's fringe benefits or perks, such a person will only be able to take some form of legal action if the benefit adds some financial worth to that person, so that they suffer financial loss when the benefit is cut. These include a company car, a subsidized canteen, share options, health insurance, a mobile telephone, an interest-free loan. These are examples of pertaining to such a situation. So where an employee wishes to cut your fringe benefit without your agreement, and there is no variation term in the contract, this will be a breach of contract. So if you don't object to the cut within a reasonable time, you will be deemed to have accepted it, and the contract of employment will have changed accordingly. So the appeal tribunal has said that if the variation refers to a matter which has immediately practical application and the employee continues to work without objection after effect has been given to the variation, then obviously it may well be taken to have impliedly agreed. If you comment below about these rules, if you have a thought, continue watching. Thank you so much. So reasonable time, therefore, really means as soon as possible after the change has been imposed. Because someone has a few remedies in relation to the loss of fringe benefits, it will always be best to try to negotiate a situation with the employer if you are an employee. So negotiating on fringe benefits, if you are in such a situation wishing to object to a cut in fringe benefit, you should try to negotiate with the employer. So they may help to reach a solution. If there is something you would accept in exchange for losing the fringe benefit that has been cut, for example, one of compensatory payment or more holiday. So therefore, you may be in a situation may wish to prepare a letter to the employer. Stay tuned, continue watching. Thank you so much. We're looking at legal remedies and fringe benefits. It will usually be in the best interest of someone in your situation to negotiate first before starting legal proceedings. It is always important to act reasonably, and particularly if it is later necessary to bring a claim for unfair dismissal. So legal remedies available to someone in your situation may include to sue for damages in the county court, also leave the job and claim constructive unfair dismissal at an employment tribunal, or if they already left the work, they can claim breach of contract at the employment tribunal and or claim discrimination. So you may also find yourself in a situation where you're suing for damages in a county court where a fringe benefit has been taken away without your consent. There's no variation term in the contract. This will be a breach of contract, and you can sue the employer for damages. Like all court actions for breach of contract, you will have to show that the cut resulted in your situation, in you suffering actual financial loss. Leave a comment below under these circumstances and let me know your views. For example, if an employer ceases paying for a health insurance scheme, this would not automatically mean that all the all involved suffered a financial loss. So you would have lost the insurance scheme, but this would only become a quantifiable loss for those who paid for a similar policy to replace such a policy. So a court will only award damages for a quantifiable loss arising out of the contract for employment. Leave a comment below and let me know your thoughts about these scenarios. So before you start court action, you must consider what it means for the future relationship with the employer. If other employees are also affected by the cut, then you may want to encourage others to join them, to join you in the complaint, as this may mean that they feel you feel less vulnerable. So if the employer's response to a threat of court action is to dismiss someone in your situation, then you will need to have work for the employer for the qualifying period to be able to claim unfair dismissal. So the special rule that allows you, someone in your situation, to claim automatic unfair dismissal for claiming a statutory right without having to have a work for the qualifying period does not apply to breach of contract action. So claiming constructive unfair dismissal, watching this video, watch the rest of the video for it to make more sense. So to make a claim of constructive unfair dismissal, you must give up your job. This should therefore only be considered as a last resort. To be eligible to claim constructive unfair dismissal at an employment tribunal, an employee must normally have worked for the employer for a qualifying period to be able to claim unfair dismissal. So if you wish to claim constructive unfair dismissal, if you are in a situation like this, if you're someone who wishes to claim a constructive unfair dismissal, and then you have to show that the employer has breached such a fundamental term of the contract or employment that you are entitled to entitled to regard the construction as being at an end. So you would be entitled to regard such a contract to be at an end. So the removal of fringe benefit may be regarded as such a fundamental breach, but whether or not it does will depend on the circumstances of each case. So, for example, in one case, an employer's attempt to put a limit on the amount of the employee's telephone bill that the employer was prepared to pay when they have always paid it in full in the past was found to be a fundamental breach of an implied term of the contract. Stay tuned, continue watching. However, in another case, the employer's decision to stop paying a petrol allowance, which they were contractually obliged to pay, was found not to be a fundamental breach because the loss was only £10 per week. Then, when the employer's average earnings were £140 per week. Leave a comment below. Let me know your thoughts. So to make a successful claim of constructive dismissal, someone in your situation also has to show that they did not accept the breach of contract. The easiest way of demonstrating this is for you to leave the job and put in writing to the employer the reason why you are leaving. It is possible to stay working in the job under a protest and to later resign and to claim a constructive dismissal, but the longer you remain working and waiting also before you resign, the greater the risk you run of a tribunal deciding that you had accepted the change. Leave a comment below, let me know what you think. constructive dismissal is not automatically an unfair dismissal. Dismissal would have to be shown to be unfair under the normal rules for unfair dismissal. If you're interested, you can learn more about claiming constructive unfair dismissal. Let us look at claiming for a breach of contract at an employment tribunal. It is possible for you who have left a job to claim for a breach of contract at an employment tribunal if you suffered financial loss as a result of such a breach. So the time limit for making a claim is 3 months minus 1 day from the last day at work. So you would be in a situation where it is still you are still employed, and also you cannot take this action against the employer. So in this situation, where you are making a breach of contract claim to the tribunal, the employer can make a counterclaim. This means, for example, that where someone has left a job without giving the full contractual losses, the employer can counterclaim for any loss that they may suffer through you giving insufficient notice for a client who has left their job. It is usually more advantageous to go to an employment tribunal rather than the court. This is because a tribunal is meant to be more informal and a quicker way of resolving dispute. If you're interested about this, you can actually consider things to consider. You can look at certain things to consider before taking a case to an employment tribunal. So the main advantage of taking action in the court rather than at a tribunal is that the time limit for starting a court action is 6 years, in 5 years in Scotland rather than 3 months for a tribunal. So the length of time in terms of deadline is a bit longer. If you are in a situation where you are outside the time limit for taking action in the tribunal, you can therefore still go to court. If the value of the compensation being claimed is more than 25,000, then the claim should be brought in the court. Stay tuned, continue watching. Let us look at a situation where you might be able to claim under a condition of situation of discrimination. So you might be in a situation where you might be able to claim direct discrimination if your employer has changed the term in your contract relating to a fringe benefit or perks on the ground of your age, disability, gender reassignment, marriage and civil partnership, pregnancy, maternity, pregnancy and maternity, race, religion, or belief, sex or sexual orientation. Where a change in the contract has had a disproportionate impact on a particular group, it might be possible for someone in your situation from that particular group to claim indirect discrimination. For example, if an health insurance scheme has been cut only for the lowest grade in the workplace, and the majority of people in that grade are members of a particular racial group or women, there may be indirect race or sex discrimination. Stay tuned, continue watching. An advantage of making a discrimination claim is that there is no upper time limit to the amount of compensation that might be awarded. A tribunal can also award compensation for injury or feelings. If you are in such a situation, you can also make a claim without having to leave your job and can claim at the same time as taking any other action. You can learn more about claiming discrimination looking at the change in the place of work. An employer may want to change your place of work. Whether or not you can do this will depend. Whether or not the employer can do this will depend on what is in the contract of employment. Most contracts of employment contain an express term about where the employee will work. If there is no express term, a term will usually be implied by the tribunal. This is because such a term must be implied in order for the contract to be workable. A tribunal would imply a term stating what the parties would probably have agreed if they had considered the issues. So this would depend on the nature of the employment and would vary from case to case. Stay tuned, continue watching. So if a term relating to the employee's place of work has to be implied into the contract, it does not follow that this will give the employer the right to move the employee. It may be that it entitles the employee to remain in their workplace. In addition to a term about the client's place of work, the contract may contain a variation term allowing the employer to change this. This is known as a mobility clause. A mobility clause is one that, for example, stipulates that someone may be called upon to work anywhere in the UK or at any of the employer's sites. Stay tuned, continue watching, leave a comment below, let me know your thoughts. If there is a mobility clause, then the employer can change your place of work, but they must not do so in such a way as to break the trust and confidence implied into the contract between them. For example, an employer who, in accordance with the contract, move an employee from the headquarters in Leeds to a branch in Birmingham, giving him very little notice and choosing not to pay discretionary relocation expenses, was found to have breached an implied term of mutual trust and confidence. Leave a comment below. Let me know what you are thinking about this state of affairs. Thank you so much. Stay tuned. Continue watching. So you can negotiate on the place of work. So someone wishing to object to a change in place of work should try to negotiate with the employer. You can also look at legal remedies in terms of a place of work changes. So it will usually be in the best interest of someone in such a situation to negotiate first before taking any further action, as your legal remedies are limited. So it is always important to act reasonably, and particularly if it is later necessary to bring a claim for unfair dismissal. So the legal remedies available to someone in your position are as follows: to leave the job and claim constructive unfair dismissal, or claim redundancy, or claim discrimination. If you are in such a situation claiming constructive unfair dismissal, so therefore to make a claim of constructive unfair dismissal, someone must give up their job. This should therefore only be considered as a last resort. So to be eligible to claim a constructive unfair dismissal at an employment tribunal, an employee must have worked for the employer for the qualifying period of unfair dismissal. So if you're in a situation where you wish to claim constructive dismissal, you will have to show that employer has breached such a fundamental term of the contract that you would be entitled to regard the contract as being at hand. Stay tuned, continue watching. So a change in the job location could be such a fundamental change, provided there is not a term in the contract, a mobility clause allowing that such a change to take place. So even if there is a mobility clause, if the employer's conduct is a breach of trust and confidence, this will be a fundamental breach of contract. For example, if you in such a situation where you were only given 1 week's notice to move to a different part of the country, such would be a situation of involving a breach of trust and a breach of also confidence. So to make a successful claim of constructive dismissal, someone in your position also has to show that they did not accept the breach of contract. So the easiest way of demonstrating this is for someone in your condition to leave the job and to put in writing to the employer the reason that you are leaving. It is possible to stay working in a job under protest and to later resign and claim constructive dismissal, but the longer you remain or you wait at work before you resign, the greater risk to run you run of a tribunal deciding that you had accepted the change in circumstances. Stay tuned. Thank you so much. So a constructive dismissal is not automatically an unfair dismissal. Leave a comment below. Let me know what you think about this point of views. So dismissal would have to be shown to be unfair under the normal rules for unfair dismissal. So the dismissal would have to be shown to be unfair under the normal rules of the unfair dismissal. It is therefore usually advisable for someone in your situation to claim redundancy as well as or instead of constructive unfair dismissal. Thank you so much. You can look more about claiming unfair constructive dismissal. Let us look at redundancy, where an employer moves a client's place of work. Such an employer, such an employee may be able to claim a redundancy payment. To be able to claim, they must have 2 years continuous employment. So they will, of course, have to leave the job. Stay tuned. So it is very difficult to give general guidelines about when a change in job location will result in a redundancy. It will depend on how reasonable it is for the client to travel to the new location and whether any mobility terms is reasonably applied by the employer. You can study more about the redundancy pay, necessarily. So claiming discrimination under these circumstances, you could be in a situation where you might be able to claim direct discrimination if your employer has changed the terms in your contract relating to your workplace on the grounds of your age. And so we're looking at the ground where you might be discriminated on the ground of age, disability, gender reassignment, and also including a marriage, civil partnership, pregnancy, maternity, race, religion, or belief, sex, or sexual orientation. Stay tuned, continue watching. Where a change in a contract has had a disproportionate impact on a particular group, then it might be possible for someone in such a situation from that group to claim indirect discrimination. For example, if a person, a change of workplace meant that a woman would not be able to organize child care to accommodate the change, she might be able to claim indirect discrimination. Stay tuned, continue watching. So an advantage of making a discrimination claim is that there is no upper limit to the amount of compensation that might be awarded. Also, a tribunal must award compensation for injury to feelings, and someone in your situation can claim at the same time as making other claims. You can also look further about claiming discrimination. Thank you so much. Stay tuned. Let us look at changes in job duties. An employer may want to change the work you might be able to do. Stay tuned. So whether or not they can do so will depend on whether the changes fall within the contractual job description. If they do not, the employer will be in breach of contract by imposing the changes unless there is a clause in the contract allowing the work to be changed. So the contract of employment may contain a term, a flexibility clause that allows the employer to change your job. Such a term will often be at the end of your job description and be written in a general way. For example, notwithstanding the above, to fulfill all duties that are reasonably asked of you. If the contract contains such a clause, the employer can change your work, but must not do so in such a way as to breach the trust and confidence implied into the contract between the two. Let us look at negotiating the change in duties. Someone in your situation may claim may wish to object to a change in their job in your job, and in so doing, you should also try to negotiate with your employer in the first place. So we can also look at legal remedies in a change in duties. So it will usually be in the best interest of the person as an employee to negotiate first with before starting legal proceeding, negotiating first with your employer, for example. It is always important to act reasonably, and particularly if it is later necessary to bring a claim of unfair dismissal. So your legal remedies are limited because a change in job duties does not necessarily result in a loss, and so there can be no claim for damages. However, if the change is included in duties, it would mean a reduction in wages. This would be a pay cut. So the legal remedies available to someone in your situation would be as follows. So you would have the option to leave the job and claim constructive unfair dismissal, or you can also claim redundancy, you can claim discrimination. So stay tuned, continue watching. So let us look at constructive and unfair dismissal. To make a claim of constructive unfair dismissal, someone in your situation must give up their job. This should therefore be considered as a last resort. So, to be eligible to claim constructive unfair dismissal at an employment tribunal, an employee must have worked for the employer for the qualifying period for unfair dismissal. So, in your circumstances, someone who wishes to claim a constructive dismissal will have to show that the employer has breached such a fundamental term of the contract that as someone in your position is entitled to regard the contract as being at an end. A change in job duties may be regarded as such a fundamental breach, provided that there is no variation term in the contract allowing this. For example, you may have lost status or management responsibility. To make a successful claim of constructive dismissal, you should also have to show that you did not accept the breach of contract. The easiest way of demonstrating this is for someone in your position to leave the job and to put in writing to the employer the reason that you are leaving. It is possible to stay working in the job under protest and to later resign and claim constructive dismissal, but the longer you remain in work before resigning, the greater the risk you run of a tribunal deciding that you have accepted the change. A constructive dismissal is not automatically an unfair dismissal. The dismissal would have to be shown to be unfair under the normal rules for unfair dismissal. It is therefore usually advisable for someone in your position to claim redundancy as well as or instead of constructive unfair dismissal. If you have worked the new job duties without protesting about the change, you will probably not be able to make a claim. This is because the employer will be able to argue that you accepted the change. If an employer is proposing a change in job duties and you are unsure about whether or not to agree to these changes, you should be advised to object, but ask for a trial period which the employer can refuse. Working an agreed trial period will not compromise your right to claim if you are dissatisfied at the end of the trial, although you may not be able to revert to the original job. You can look more about claiming constructive unfair dismissal. Let us look at redundancy. If an employer changes your job duties, it may be possible to make a claim of a redundancy payment as well as unfair dismissal. So you would have to show you will only get one of these from a tribunal. So you would have to show that the change has been so fundamental that the original job has ceased to exist. When considering this, it is important to look at the function of the job, not how the job is done. For example, a secretary who is asked to upgrade to a new computer wouldn't be able to claim a redundancy payment. This is because the job of the secretary still exists. It would usually be advisable for someone in your position complaining about a job change to claim constructive unfair dismissal as well as redundancy because the compensation could be greater. You can look more about redundancy. Let us look at claiming discrimination. If you are in such a situation, you might be able to claim direct discrimination if your employer has changed the term in your contract relating to what you are expected to do on the grounds of your age, disability, gender, reassignment, marriage, and civil partnership, pregnancy and maternity, race, religion or belief, sex, sexual orientation. So if a change in the contract has had a disproportionate impact on a particular group, it might be possible for someone in your position from that group to claim indirect discrimination. For example, if the people at the lowest grade in a workplace have had their their descriptions change to include unpleasant tasks, and the majority and the majority of people at that grade are of a particular racial group, they might be able to claim indirect race discrimination. An advantage of making a discrimination claim is that there is no upper limit to the amount of compensation that might be awarded. The tribunal can also award compensation for injury or for injury to feelings, and someone in your institution can claim at the same time as making other claims. You can look more about claiming discrimination. So let us look at qualifying period for claiming and unfair dismissal condition. So an employee has to have worked for their employer for 2 years before being able to claim unfair dismissal. So in all cases, an employee may be able to make a claim of automatic unfair dismissal or for dismissal for a redundancy reason, for discriminatory reason, and most of these claims don't require the employee to have worked for any length of time. So you can look more about identifying unfair dismissal and who can claim it. So thank you so much for watching this material. We have been today talking about work in the United Kingdom. We have been producing this video in relation to the rest of videos already posted previously. So if you have watched this far, you're a champion. Thank you for your help, for also participating. And the purpose for this is what I consider to be educational in terms of contract, which we spoke about contract of employment as part of work in the United Kingdom, is to teach viewers or to help them or to guide them on the information, also on the knowledge of contract of employment, which is a very important and fundamentally important aspect of their lives. Work in the United Kingdom is the primary source of income. In a modern society, you rely on your income through work and employment, particularly, and also the condition of work involving contract of different types, such as we have discussed, is extremely important. And also it is important and also empowering that you learn a thing or two about the law and policies on work in the United Kingdom, if you live in the UK and also in similar countries in Europe or America. Because we live in a modern world where you are expected by the state and also the relevant authority to be independent, to look after yourself, and therefore self-learning is so important. You can visit gov.uk for the additional information and the rest of the resources found in many different websites, which you can look for yourself and do a study. You can maybe visit other YouTube channels, find discussions surrounding employment, work in the United Kingdom. The other aspect of work, as we have discussed in the other videos, involve financing. People who need help by the government to improve condition of their income. And all this exercise have been relating to the cost of living crisis, which is relevant in terms of income. And so the argument for income maximization has been at the forefront of discussion. If you watch the rest of the video, and I've actually made several claims in terms of working, where I've made suggestion that the government need to increase the level of pay by statutorily obligating employees rather, no, employers to increase the minimum wage at least £15 or £20 per annum, ideally after tax and NI in terms of net. So this is from the top of my head, and so experts who advise government should know more than me. But I live and work with ordinary people who are facing poverty in the United Kingdom. The United Kingdom is the sixth richest country in the world, and it is a shameful conduct of the government and also of society to allow one person being poor in the UK and also in Europe and America, Asia, and let me say also Africa. The level of poverty in Africa is disgraceful, and leave a comment below if you live in Africa or another continent. And the condition of work should be improved to get the people of the world out of poverty. That is the basis of this program, and also the underlying arguments why I'm undergoing this process. Leave a comment below. Let me know what you thoughts are, and also when you watch this video, click like. If you haven't subscribed to this channel, and click like and notification bells so that you don't miss any of my videos. Your support is valued and valid, and also sharing the video with family and friends. I'll see you in the next video. Thank you. Bye bye.